Well, thanks everybody for coming today. I'm really pleased to see you here. And today is going to be a real whistle-stop tour of IP and the basics of IP. And this is the start of a series of 18 webinars that I'm doing. Some of them are going to be much deeper nosedives into IP. And I think you'll find some of them really entertaining because I'm going to go into things like lookalikes, what exactly is a lookalike? How far can you go before you've copied something? So I've got some entertaining presentations coming up. But today we're just going to really talk about the basics of intellectual property and why it's really important. And I call intellectual property invisible wealth. And I call it invisible wealth because for many businesses, they just don't see the value of intellectual property. It's not like plant and machinery. It's not listed on any asset register in many cases. It's obviously not balanced in most cases on the balance sheet of a company. So why is it so valuable? Well, today, hopefully, you'll find out why I think it's so valuable and hopefully be able to apply that knowledge to your business. So without further ado, let me share some slides for you. Here we go. Right, so IP, the basics. Oops, we go into that. And let's have a look. First of all, who are we? Why are we to tell you what you need to know about intellectual property? Well, intellectual property is what we do. It's our specialist subject, and that's all we do as a law firm. And we help people protect, identify, and grow their intangible assets, and thereby grow their often invisible wealth. So it's really important that people be able to identify exactly where the IP is. Oh, hang on, I've been presentation window. So you dream it, we protect it. That's what we say. So why listen to me? Well, I've been doing this job for a long time, 30 years or so, and I've got a wealth of experience with intellectual property law, and there's not a lot that I haven't seen. So I've got lots of war stories about intellectual property and how it's been useful for people over the years, and indeed the elephant traps that people have fallen into. Why do I call it invisible wealth? Well, it does have a wealth, it does have a value within businesses, but that's often not actually not understood by many people. And sadly, it's not understood by a lot of accountants, which is very much one of my frustrations and bugbear in life, that accountants don't put intangible assets on the balance sheet. And I know certainly with a lot of companies, when they come to, for example, buying or selling their company or buying and selling another company, IP is just not mentioned and it's not recognised as such very often until the 11th hour. So I want you to take the first step that I want you to think about when you think about your intangible rights is, what is it that your business has actually created? How does your business stand out from the crowd? Um, and once you've identified that, then you can sort of see how you can use intellectual property to make you identifiable and distinct from other people, because that's very often what IP is all about. So let's start our whistle-stop tour of IP. So copyright, what is copyright? Well, copyright, a lot of people don't understand this, but actually copyright is often the most disputed arena of intellectual property. And copyright is also worth a massive amount of money to the UK's economy. Why is that? Because all our creatives use copyright. Copyright arises in written materials, photographs, drawings, music, database, software, the Internet of Things. It's all based on copyright rights. It's a right that arises automatically. The first owner is the creator, the author of the copyright, and it's not a registrable right in the United Kingdom, nor in most of the developed world. Although there are parts of the world where you can register copyright and where people routinely do, for example, the USA, China. And the beauty of registering it is obviously it then creates a first date, if you like, and an ownership right, which is less visible, in fact, in Europe and the most of the world. Where you've got a registration, you've got an owner, you've got details of what's actually been created and when it, more importantly, when it was created. Certainly things like music, certainly things like books and written material are often registered in places like the States. Um, Employees is a difficult one sometimes with copyright because you've got to make sure that your employee who you've employed to do a particular job isn't owning the copyright or creating it in his or her own time. And sometimes with quasi-employment relations, you are actually going to have to require an agreement for somebody who's employed on a subcontract basis or an agency basis to assign the copyright to you, because even though you've paid for it, you don't necessarily own it outright. It's really important it's copyright for many businesses, because when you think about it, there's copyright in the website, copyright in social media, photos, software, all those sorts of things. So if you've created, for example, a unique database for your business, or you've created you've had created a unique piece of software, then there's copyright in that. And it's really important to retain the value of your copyright, is to make sure that you own it. And that if the company is sold, that you retain or the company is moved on to another person or subcontracted out, that you own those rights so that you can license them out, so that you can make money and monetize them. Copyright, sadly, is often overlooked as a business asset until there's some kind of a dispute. And the theft of copyright material has never been easier. It's incredibly easy to copy photographs. It's incredibly easy to copy text and materials and layouts and all the rest of it. And of course, this is all aided and abetted now by artificial intelligence. And that's a whole book of rights on its own in terms of AI and the intersection with copyright. So what do you need to know about copyright and protecting your ideas? Well, make sure you own it is rule 101 of copyright. If you're using copyright on particularly on materials that you're giving out to people, put your copyright notice on. It's a C in a circle. It's very easy to insert that onto most material. And if you're using material under license, for example, you've got material that's used by franchisees, you've got people that are using as teachers are using your material. Again, make sure that you've got proper licenses in place and that you have got proper terms and conditions covering how that copyright material is going to be used within your business and how it's going to be monetized. And think of how much poorer the world would be if we didn't have copyright. I mean, all the creatives now are using copyright, and that's what our economy is based on. It's based on the creation of copyright music, broadcasting, software, artificial intelligence, database rights. It's a massive subject and it's a massively complicated one. Copyright's often referred to as layers of the onion because there are so many components to it. Trademarks, whistle stop tour of trademarks. Again, hugely important part of modern trade these days. Logos, slogans, names, colours, all really important. One of the webinars I'm going to be doing is, in fact, on lookalikes and dupes. And colour is massively important in this arena because we're such a visual society that often colours are associated with particular kind of characteristics of goods and services. So say, for example, the blue on here is often it's associated with being clean, it's associated with being some cool natured flavors, that sort of thing. So colours are really important. Colours are really important often as trademarks or brands or part of brand get-up, because they are internationally recognised. So a particular word mark might not be recognised, but colours are. Hence, companies like Tiffany have got a registered trademark for their very distinctive sort of bluey green, and BP have got a Pantone of green registered for all their oil-based products. So think about all the different names and slogans and logos and colours that a company uses. Think about how they need to be protected. You're obviously not going to register everything as a trademark, but key logos, key names definitely need to be trademarked these days. And why, people sort of often question what is the value in a trademark and a brand. Well, put very, very simply, people return to brands that they know. This goodwill it causes customers to be sticky. They come back time and time again because of the label. They come back because they know that, for example, a BMW car has got certain build characteristics and qualities about it. The registration is key to making sure that your brand is not copied. And registration also is globally important now because quite often brands don't just stay within the country that's originated them. People will go international fairly early on in their career in terms of business development, in terms of it being something that you move into different markets. You might go to the USA because you've got great presence on YouTube. You might go to South America because, again, you've got great presence in social media and you've got a product that's attractive to that particular market. It's an incredibly busy registration process these days. And one of the things that we advise people to do always is to get a full and proper professional search done before you even start to register your trademarks to make sure that they are going to survive the examination process. Again, specifications, really important to get the specification right and to make sure that your specification is really fine-tuned. The days of you being able to broadly register a whole category of goods where you're not using half that specification are long gone. And if you want to register in the States, for example, after 5 years, the USPTO will ask you which elements of the brand that you've used, and you're going to have to prove it to the examiner. And you can lose your whole trademark if you can't do that. So specification, hugely important. Global brand recognition, yes, absolutely. It's a strategic task to do that. And we quite often help companies with that because there's a whole variety of ways of doing it that will hopefully get you maximum protection, but not cost you the earth. If you file separately in different countries, it's going to be more expensive perhaps than doing a more global registration using what they call a WIPO registration under the Madrid Protocol. That's World Intellectual Property Organization type registration. That's one portal that you go into and then you designate the countries that you want. That can be less expensive than filing individually. Just a word of warning on that. Not every country in the world is a member of the WIPO community. Not yet, anyway. Moving swiftly on to another very, very popular area of intellectual property rights, design rights. Now, it's really important to distinguish at this stage two different types of design right. A design covers the 3D element of an item. So, for example, if you've got some sunglasses or furniture or lampshades, it will cover those design rights. But there are two types of design rights. There's unregistered design rights and there's registered design rights. Registered design rights cover the look and eye appeal of something. So if you have designed, for example, a new type of sunglasses, many years ago, I remember the Oakley sunglasses, the frame of an Oakley sunglasses, they were registered as registered design rights. Some car manufacturers use spare parts. They register the design rights there. Certain toys, certain functions, certain elements, for example, of furniture that are aesthetically pleasing can be registered as design rights. And the importance of a design right is not just that it becomes a registered right, it's what they call non-examined. So it's fairly straightforward to get your design right, although there's a whole set of rules around how you have to file that and the line drawings and how it's covered and how it's classified. But once you've got a registered design right, you can get a monopoly on the design right of something for up to 25 years. Now, commercially, that's hugely important, not least because unregistered design right, which is a branch of copyright which arises when you've created something, so there's no registration process, it's simply when you create something in a 3D effect, you get your rights so automatically arise at that point. But unregistered design rights are relatively short-lived. And in fact, in the UK, the unregistered design right, an absolute monopoly over that design is actually limited to 5 years. The second 5 years, you can make people take a license of it if somebody copies you. If it's a European right, unregistered right, the design right's even shorter. It's 3 years. So commercially, that's a very short period of time. So if we're looking at the real value of a design right, I would suggest that you really want to have a look at registration of design rights. And interestingly enough, a lot of UK manufacturers have cottoned onto this, and it's one of the most growing areas of intellectual property in the UK is registering design rights. So the design right registers the look of something. It can register specific features of the design, or it can register the design as a whole. So it's important again to get proper advice on the elements of the design that need protection. And it's useful, very useful for defending yourself when there's a dispute and somebody else comes into the market with a very similar product, the same or a similar product. And it's just another bite in the cherry. It's another way that you can put protection and a thicket of protection around the kind of innovation within your company. So don't forget design rights. They're a bit of a Cinderella right, but nevertheless extremely important. Moving swiftly on to patents. Now, patents are massively valuable, but a lot of people say, well, they confuse patents. They confuse, do I need a trademark? Do I need a patent? Well, let's start at the beginning. A patent covers the new product or process in something. So a new product might be a completely new pharmaceutical, for example, a completely new therapeutic drug. Or it may be, for example, a process. It may be a more efficient way of making that drug or making a particular item. So products and processes are covered by patents. The law says that new innovation of this kind must be new, it must have an inventive step, and it must be novel. When I say novel, I mean not obvious. And there's a bit of a test for that. It's a bit of a dark art is getting a patent through that particular stage in the examination process. But patents, nevertheless, are hugely valuable. They can take 2 to 4 years to obtain as a registered right, and that is because they're very carefully examined by the Intellectual Property Office. The Intellectual Property Office will then go into some detail about what your patent is. Have you carefully identified the elements of your patent that make it unique, that make it inventive? And they will ask lots of searching questions. I've once or twice seen people try to get their own patents. It is an exceptionally difficult thing to do. And the vast majority of patents that are drafted by non-patent attorneys are almost unenforceable. So I would say get proper advice on this. Go to a patent attorney. Go to a patent attorney that specialises in the kind of technology that you're working in. So if it's, for example, it's a chemical patent, or if, for example, it's electronics elements that you're trying to patent, then make sure that you speak to a patent attorney who's got the relevant experience. And why are patents really valuable? Well, they give you a monopoly for 20 years, which commercially is very important because it means you can keep other people out or you can license your rights for those 20 years. But because they're such a valuable right, the government also incentivises them by way of tax schemes. So there are tax advantages to having a patent. There's R&D tax credits for general research, but the real valuable part of the tax scheme that's attractive to many companies is the patent box, because the patent box allows you to pay corporation tax at 10%. So where you're making money off patented products. So that makes your company extremely valuable and it makes it far more profitable. So patents are an absolutely essential thing for anybody who's really innovating. There are some things which are excluded from patenting. Things, for example, like software, so just improving software or improving a way of doing business is not patentable. Things like improved surgical techniques are not patentable. But there are other things that are patentable. And again, just as an illustration of how speaking to the right person can help, I was listening to a podcast the other day of a lady who'd come up with this idea of football laces on football boots for kids, whereby they automatically kind of bound together so that the laces didn't come undone on a football pitch, which, as you know, can be dangerous if you're running around and you're playing football. And this lady had been told by a number of people that what she'd invented couldn't be patented. But in actual fact, she was wrong. And when she went to a manufacturer, the manufacturer suggested that their patent attorney looked at the innovation that she'd created. And he said, no, I think we can get this patented. And lo and behold, she did get a patent on it. And of course, that's very, very useful in enforcement. Another everyday example of that is Sarah Davis off Dragon's Den, the lady from the Crafter's Companion. Again, Sarah Davis actually had a very good idea many years ago about making an envelope, a self-folding envelope, and a device that helps you get exactly the right size, fold the paper, make exactly the right size envelope. Again, she patented that, which was incredibly forward-thinking of her, and I know that she's defended that in court on a number of occasions. So patenting things, again, it's useful to get strategy, useful to think about. Again, it's geographic in nature. You might want a patent in the States. You might need a patent that covers the EU or even that covers China. So if you're thinking of patenting, you've got some innovation, please do speak to an expert about that. Further rights. Well, there's an absolute bundle of further rights here. Data and databases, plans, process systems. AI and other technology are absolutely revolutionizing this area of copyright at the moment, database rights and copyrights in things. But the value that that is delivering to companies is absolutely astonishing. And again, I'd like to give you a kind of an example of that. A couple of years ago, I met some database rights people. Well, they were working in fact, with the airline companies. And what they were doing was helping the airline industry to plan holidays properly, using a lot of consumer insights, using a lot of consumer databases. They were planning using their own algorithms when they needed flights, where they needed flights to, what the pricing of those flights would be, what the pricing of those holidays would be. And that's all exampled now with dynamic pricing online. And you see that in a number of industries, but the big one, of course, is the airline industry. Because if you've ever booked a flight or you've ever looked at a flight and then gone back and found that the price has gone up, you know it's all to do with dynamic databases and these algorithms there that can see you looking at a particular holiday or destination. Software, absolutely critical these days. The Internet of Things is critical to the value in businesses. If you've created a unique piece of software that enables you to do something that nobody else can do, data that can give you invaluable insights into what's happening in your business, then that is hugely important. Obviously, it's a branch of copyright is software, but do think about this and creating how it can be the algorithms, the questions, the assembling of data that software can do in seconds that would otherwise take humans a long time to do. Confidential information. We see that quite a lot now. Not everybody wants to patent their new improved way of manufacturing something or a specific recipe. For example, the Coca-Cola recipe is still a trade secret. There are plenty of other illustrations of trade secrets you find sometimes with pharmaceutical manufacturers, that they don't want to let other manufacturers know how efficiently and effectively they are manufacturing something. A further thing to be aware of are IP and employees, business partners, suppliers, collaboration, service users, etc. Don't automatically think that they've assigned their rights to you. I've seen over the years a number of cases where, for example, overseas agents have claimed copyright in brochures that they've written or in translated versions of brochures. I've seen suppliers claim rights in a design that somebody's done because it's been manufactured by somebody else. So they've told the manufacturer exactly what they would like to have, and the manufacturer has then thought, oh, this is great, we'll go and use it with different people, other people, and lo and behold, they've gone off with the supplier's rights. I've seen that in contracted out manufacturing on a number of occasions. Again, don't assume that every employee that you employ who creates something for you, that you own those rights. You may well do, but it's important to have specific clauses in people's employment contracts that what they create is created for you, so that they're not going off and doing their own thing, or even worse, leaving and then asserting rights in designs or whatever that they've done whilst they've been working for you. Oops. Ooh. Hang on, I think I've gone too far there. End of slideshow. So, sorry, I've missed off the last slide, but what I am going to tell you is some of the other webinars that we've got coming up, which we'll send round afterwards after this webinar. IP registration is the next one, getting it right first time. An awful lot of people get this wrong, and it causes no end of problems, because once you've got the base registration incorrectly registered, it makes it very difficult to go global with a particular brand or design right registration. So the next seminar is all going to be about IP registration and why it's important to get it right. Webinar number 3 is about online IP, because very often if there's an infringement action these days, it's originated from being an online. Webinar number 4 is going to be the importance of global IP rights, which will help anybody that's looking to export, looking to go overseas, and looking to maximize and commercialize their intellectual property. Webinar number 5 is about managing an IP portfolio, because again, that's important for bigger companies. Once you've got a range of trademarks, once you've got a range of designs, you've got a range of patents, it's important to have the IP portfolio properly managed and to have professional advice. Webinar number 6 is about intellectual property for creatives. And I've done that specifically at a non-legal audience, because I want them to understand how important intellectual property is for their creatives. Thanks. The rise of copycats is another webinar, how to avoid being duped. That's really key. Luxury brands, how elite companies create stories and add value through IP. I did a podcast on this last year with Elizabeth Solaru. IP for exporters, confidential discussions, how to keep things confidential. So I've got a whole series of webinars coming up, which I think you will really appreciate. And why is IP invisible wealth? Well, let's just recap on that. All businesses have IP, but a number of them don't leverage it properly. These intangible assets are not recorded on the balance sheet unless it's bought in, and they're not recorded in the accounts. They're often not on asset registers. So I ask you to rethink that. Ring fencing your intangible assets keeps you unique, and it stops your spark from leaving the business. It stops your key elements from moving on. It provides goodwill. It provides licensing opportunities. It creates unique selling points. It creates a reputation for you. and it minimizes if it's all properly managed, it minimizes the impact of disputes on your business. You know, we lock up the office, we lock up the warehouse, we lock up the crown jewels, don't we? But for some people, they just leave the IP absolutely on the table for other people to take. And I'm urging people to rethink that. So start small, identify the assets, and then identify the risks and opportunities. And if you want to have a chat with me, then please, I offer, you know, any potential client a 15-minute free consultation to talk about protection and to talk about the way that you would scale your protection and the way that you would add value to your business and the way that you scale the protection to add the value. After this webinar, you will get a recording of the webinar, and you'll also get an IP in business questionnaire. And after every webinar that I do, there'll be really key handouts and cheat sheets. But if you want to contact me after the webinar, please do so. It's liz@virtuosolegal.com. Please send your questions in. Thanks for listening.